Okay, so today we're going to cover a few different topics. I do a fair amount of litigation. I do a lot of advice and counseling. Actually, in Santa Barbara, I do much more advice and counseling, and in Los Angeles, I do more litigation. And then statewide, I do litigation as well. So there's just a lot of great lawyers that are well established. So I work a lot with smaller employers up here that kind of fly under the radar of the big firms up here. And in Los Angeles, there's just been so much work that I'm going to make the slideshow, the PowerPoint slide deck, available. I can send it by email to anyone that it's in attendance, so it'll have the nuts and bolts on it. And if you have questions about what statute is it in particular that applies here, I can follow up with that. And there'll be a couple areas where I point out that there are twists and turns in the law that I don't want to confuse you today by overloading you. I'm already going to overload you a little bit, but I don't want to overload you and then confuse you on top of that. So I'm going to try and keep the confusion to a minimum.
Do you want people to interrupt you as you go along, or do you want them to wait with their questions?
I'm fine if you feel you have a burning question. I'll also take questions at the end. So let's first look at what we're going to cover today. So first I want to talk a little bit about the background of these kind of laws so that you understand both the what and the why. I think it's important to know why it is that these laws exist and why it is that some people feel they're very important. I think that helps you understand and puts things into context. I'm going to talk first, after I cover sort of the background, I'm going to discuss the current state of the law. Now, this is an area that's very much in flux. I suspect many of you probably are on mailing lists for various law firms or SHRM or PIRA or other organizations that keep you up to date, and I'm sure that they're peppering you with information about this, and so you see that it is an area in which there's legislation. So first I'm going to talk about what you need to comply with today. And then I'm going to talk about the proposed legislation that I think is likely to become law, perhaps with some tweaks. But and my thesis is that ideally you would comply with the proposed legislation now, because that way it won't become sort of a shock when it does get enacted, which I'm sure something will. California leads the country, as you're all aware, since you're in this, in legislative and judicially created employment laws, very, very strict venue we are in. And I feel like if employers recognize their additional obligations and try and comply with them, I don't feel that they're too onerous, really, and they are drawn from the Federal Equal Employment Opportunity Commission guidance on this area. So they come with a certain amount of gravitas that in enacting the law, I suspect, will be very close to what the current legislation is. And then finally, I'm going to talk about the Fair Credit Reporting Act, because that is, in many respects, equally, if not more important, and as I'll discuss briefly, largely because of the class action lawsuits that have come about throughout the country for mass violation of the FCRA requirements. It's gotten some big companies in trouble, and obviously smaller companies can get in trouble as well. So let's first talk about what is Ban the Box. So it's been described as a grassroots effort to remove the box that's on an employment application wherein an applicant needs to identify whether they've been either convicted or charged with a crime. I think I would be surprised if there's many applications that say charged with a crime, but I could be wrong. It's also been referred to as a fair chance law. 24 states, at least the authority that I have is 24 states, and more than 150 cities and counties have passed some type of ban the box law. And what it is that the idea that you will conduct a job interview first to see if someone is qualified for the job, and then do whatever background investigation you feel is necessary, an analysis of whether the conviction is job-related before you basically turn someone down because of a conviction. More of an, as you'll see also as we get into what the requirements are, it's much more of an individualized analysis as opposed to a bright line standard. I think that's what the legislation and the guidance is really, the EEOC guidance is really pushing for, is an individualized, narrowly tailored analysis of an individual applicant's history and how that will relate to a particular job, as opposed to a bright line standard that we're not hiring anyone that has any kind of criminal background or has this particular conviction. So the why of it is the notion that creating a fair, robust, fair chance, or the creation of these employment laws ensures a fairer decision-making process, requiring, as I said, employers to consider job relatedness, time passage, and mitigating circumstances when refusing an applicant based on their criminal record. And I think that the philosophical background is the premise that anything that makes it harder for an ex-offender to get gainful employment makes it more likely that they will offend again. So I think that's really societally what we're looking at. Now, there are people on the other side, there are critics that say that without the box on the application, employers may be more likely to assume that someone who is of a certain racial profile has a criminal background. And I'm going to leave it up to you whether you think that that is a decent argument, but that's been put out there as a reason not to, and there's actually been studies theoretically supporting that position. I think even though that argument's out there, I think we're going to be moving forward with ban the box. It's definitely the wave, if you will. So turning our attention to the current law in California, it's presently unlawful to consider an arrest or detention that did not result in a conviction, a referral or participation in a pre- or post-trial diversion program, or a conviction that has been sealed, judicially dismissed, expunged, or statutorily eradicated. More recently, the regulations have been enacted to relate to records of juvenile convictions. Now, that doesn't relate to juvenile applicants necessarily, but people at whatever age concerning records that attach to their conduct or alleged conduct when they were juveniles. So arrest, detention, and other records or other criminal records while the person was subject to the jurisdiction of the juvenile court. So that would mean when the juvenile court, of course, attaches when you're 18 years old or younger. In any non-felony conviction for possession of marijuana less than, older than 2 years. And so now that recreational marijuana has been legalized, depending on what the regulations are that are ultimately enacted around that, that could even be thrown out altogether, conceivably. And also a criminal history if it will result in adverse impact on a protected class. So I wanted to take this opportunity, and this is going to be a little bit of a brief aside, but I think it's an interesting thing for all of you to know in your role as this. Some of you may already know it, some of you may not. Most of my, I'll say 80% of my practice relates to discrimination. To the extent I'm in litigation, it relates to discrimination claims. And there are two kinds of discrimination claims. One is a intent to discriminate, intentional discrimination, or what we call the disparate treatment, disparate treatment discrimination, in which you treat one individual different than another individual based on one of the protected characteristics. So in California, age, race, religion, gender, disability, which includes medical condition in California, religious practices, religious preference, genetic characteristics, sexual preference. So there's a whole host of protected classifications. So in disparate treatment claims, you're establishing that an individual was treated differently because of had one of these characteristics. There's another kind, a second kind, called adverse impact discrimination. And what that refers to is what we call a facially neutral policy that has an adverse impact on a protected class of individuals. So here we would be talking about information that's collected on an employment application, which is facially neutral. So on the surface of it, you're simply asking if the person has a criminal record. But by precluding those individuals from getting a job, it has a disparate impact on certain racial, largely it's going to be racial classifications. So I'm just basically going to take you through real briefly the burden of proof and the shifting here, because I think it's kind of an interesting thing, and it'll help you understand what goes on in these type of cases. So first, at the outset, the applicant would be trying to prove that the employer's background screening process has an adverse impact on a protected class. And the way that this can be done is through use of statistics about national statistics, local statistics about we hear on the news that more African American men are incarcerated than, let's say, Caucasian men in various venues throughout the country, nationally as well. So you would probably not have a difficult time if you were an applicant trying to prove that. The burden then shifts to the employer to prove that its policy is both job-related and consistent with business necessity. Now that, of course, comes into play if certain kinds of businesses that are regulated by the government, healthcare facilities, people that work with the elderly. There's all sorts of specific industries in which that may come into play. However, the policy must be, and I'm quoting, appropriately tailored to the position at issue. And there's a set of factors from a federal court case called Green versus Mississippi Pacific Railroad, which talks about time span between the conviction and the application, the nature of the criminal conviction, and the nature of the job that's being sought. So the factors come into play. Then the burden will shift back to the applicant to show that there's a less discriminatory policy. So even if the employer can show that they do have a narrowly tailored policy, the applicant can still defeat that with its own showing. Now, if an employer decides against hiring an individual based on information that is gained through criminal background search. So now what we're talking about here is you find out that they have one of the pieces of information that survives the different things that I said were unlawful. There's still certain things you can rely upon. And the employer decides that they are going to refuse to hire this person, then they are required to give notice of the disqualifying conviction and an opportunity for the applicant to show that it's factually inaccurate. So what they have to do is send a letter identifying the conviction and give the applicant a certain amount of time. I believe 10 days is maybe the current. Now, if the conviction is shown to be inaccurate, obviously you can't use it as a basis for denying employment.
Talking about mistakes then?
Yes.
Okay.
Right. There are exceptions for employers that are subject to as I said, mandatory pre-employment screenings and prohibited and laws that prohibit individuals with certain criminal records from holding positions, and again at the healthcare facilities. Now, you may have already heard that there are more stringent ban-the-box type laws in place in Los Angeles County and San Francisco County. And I thought rather than going into those, because it would probably just confuse you and not necessarily serve any purpose if you didn't have businesses in Los Angeles or San Francisco, that I wouldn't include those, but I thought I'd alert you to them. And if any of you do have businesses with offices or centers in those counties, reach out to me and I will happily discuss with you what the specific requirements are. Now let's talk about what's pending now. So Assembly Bill 1008 is the pending law, and it provides that you cannot include on an application any question that seeks disclosure of an applicant's criminal history. So you can see that it's much more stringent than the existing law. And you cannot inquire or consider criminal history before an applicant receives a conditional offer of employment. So for example, if the offer of employment is going to be conditioned upon your completion of a satisfactory completion of a drug test, that would be a conditional offer of employment. But according to the proposed law, you would not be able to even consider any criminal information until you're in a position to make that offer, and have made the offer, actually. You would not be able to consider misdemeanor where no jail time is possible. So let's talk about felonies versus misdemeanors. Is that a distinction that everyone in the room knows? Some of you may know. Okay, so a felony is a crime that is punishable by a year or more. And a misdemeanor is punishable for under a year. Now, I don't know whether there's some overlap in the sense that a misdemeanor could have jail time over a year, but what this is concerned about is no misdemeanors where there's no jail time possible, which would be a pretty minor infraction. Also infraction or misdemeanor convictions that are older than 3 years. And then felony convictions, again, those are convictions where prison time in excess of a year is possible. Not necessarily guaranteed, but possible. Older than 7 years would not be able to be, the employer would not be able to consider those. And again, the trend toward an individualized assessment as opposed to a bright line standard is where we're going. So an employer needs to be in a position where they can show that they've done an individualized assessment before they can deny based on a criminal background search. And the question is, does the conviction have a, quote, direct and adverse relationship with the specific duties of a job? Now, if the employer decides to deny employment based on the criminal background, they must provide written notice. And it's pretty specific. So let's call this the first written notice. The first written notice must identify the specific conviction that they're relying upon. So if there's only one, then needs to list that, but if there's many, then identify all of them. Provide a copy of the conviction history report, if any, that was obtained and relied upon. Now there's going to be overlap. In a moment, after I get through this bit of legislation, I'm going to talk about background searches, and you're going to see that there's some overlap on this. I think it's best to just keep them separate and make sure you're complying with both. You're going to need to provide examples in the written notice of mitigation or rehabilitation that you would consider. So for example, if someone has attended, let's say that the conviction was for some type of violent act or assault, something like that. If there was evidence that the applicant had complied with anger management training or something along those lines, that would certainly be mitigation or rehabilitation. Or employer would consider, excuse me. So, and then you need to provide your notice of the right to the notice to the applicant of their right to respond within 10 days. Now, the applicant may then, within that 10-day period, offer the evidence either that the information, criminal background information, is inaccurate, or offer the evidence that they've undergone some type of rehabilitation or mitigation. Now, as written, the bill would prohibit the employer from disqualifying if the applicant does show some mitigation or rehabilitation, which I think is a little bit of a problem because it leaves wide open how much is necessary. I mean, if they've just kind of thrown something in there and the employer feels it's rather dubious, it would suggest from the language of the bill that you'd have to employ them anyway, which I don't like leaving things loosey-goosey like that, so we'll see what happens with that. Could, of course, be source of litigation. If the employer thereafter makes a final decision to deny, then they need to give a second written notice. And in this second written notice, it needs to let the applicant know that there is a final denial. If there's an existing procedure to challenge this decision, that should be included in the letter, or a statement that there's no existing procedure. I would do that. Eligibility for other positions or not. So if there's another position that's less sensitive that the employer would consider this applicant for, then that should be included. And again, if there's not, then I would include that in the letter. The earliest date that the applicant can reapply. So again, we're down to that 7 years for a felony. So if that's what you're relying upon, then you would put when the 7 years expires. And the right to file a complaint with the DFEH in the event that you feel that there's discrimination, that it's a disparate impact.
You still have a lot of support.
Yeah, I think it seems like it's really going to go. So any questions about those? So the criminal background questions, ban the box. Let's focus on that for now. Any questions you guys have for me? You're making it easy. Let's talk about the Fair Credit Reporting Act requirements. So the FCRA regulates collection, distribution, and use of consumer information. So it's a law that applies in the mortgage lending area, it applies in the credit area, as well as in the employment world. And background checks can contain information from a variety of sources. Typically, it will have where the person's lived for a long time, depending on how in-depth they are, how much you pay for them. Public records, including criminal convictions, addresses, bankruptcy filings, employment verifications, criminal record searches, things like that. And I wanted to let you know how costly it would be if you don't comply with this. Now, with regard to the laws that we've just talked about, basically they're penalties. I believe you could probably bring a lawsuit. In fact, I'm sure of it. You could bring a civil lawsuit for violation of the criminal records ban the box type laws, the existing one, or once the other one is enacted. You can bring a lawsuit for violation of that, and the damages, the remedies would be the damages. For example, if someone applied for a job that paid $18 an hour for a 40-hour week, and you denied them that job, and it's found that you did it in a discriminatory manner, relying on background or criminal record that you're not supposed to rely on, then I think they could bring a civil lawsuit, and the damages would be the loss of income, what we call front pay, or in this case it would be back pay from the time they made the application until they find other employment. So that would be sort of their damages there. And in this case, I think the same would apply, but it seems that there's been a lot more litigation in the FCRA arena, particularly against huge employers. For example, Dollar General agreed to pay a $4 million settlement in response to a claim that it didn't properly notify more than 200,000 applicants that background checks would be obtained. Food Lion, a company I'm not familiar with, paid almost $3 million for 2 separate class action lawsuits, and this because they failed to apply to provide applicants with a standalone disclosure form. We're going to talk about that in a minute. Chuck E. Cheese agreed to pay $1.75 million in settlement that claimed they provided improper background check notices during the hiring process when they did not provide a separate standalone authorization form, and their disclosure form did not include the checkbox for applicants to receive a copy of the consumer report. So let's talk about what's required under this. First, you must provide to the applicant a certification that you will use the information for permissible uses. So it needs to specifically state that you're not going to violate the equal protection laws. It also needs to state in the certification that you're going to comply with the proper process for obtaining the report. I should mention also that these rules apply when you use a third-party agency to do your background search, which is really most common, but it's possible for an employer to do their own background search. And if you work with an employer that does that and you want to find out what those requirements are, let me know and we can go through that, but I don't want to make it more complicated than it already is, because it's more common for people to use a third-party company. You next need to disclose to the applicant that you may be obtaining a consumer report on them. The disclosure form must be a standalone document. So we have both a certification that you're going to use the credit report in a, I call it a credit report, in a permissible purpose, and a disclosure, again, standalone document. And in California, the law is a little bit different. So the Fair Credit Reporting Act is a federal law. California has a very, very similar law of its own, and all you need to worry about is making sure you comply with both. So the only thing California adds on this one is that you need to obtain a new consent every time you're going to do this. So you might do it at the outset of employment, but you also need to do it anytime you're going to do it later in employment. And by consent, I mean the authorization form. You can't bury the authorization in the employment application itself. It needs to be a standalone form. And I think this was part of what got Chuck E. Cheese in so much trouble, was they were burying it in the form. And the other thing about California that's a little different than the federal is, so in California, you have to limit the public record search no longer than 7 years, except for bankruptcy records, which is 10 years. Now, if after receiving the report, the employer decides not to hire the applicant, you must provide a copy of the consumer report to the applicant, provide them with what's called a pre-adverse action letter, which I'm going to go through in a minute, and then provide a copy of a circular called a summary of your rights under the Fair Credit Reporting Act. And if you have trouble finding that circular and you need it, let me know and I can find it for you. So let's talk about the pre-adverse action letter. This is the first letter. It needs to give the applicant an opportunity to dispute the information in the report. So you need to identify the report you're working, well, I guess you need to, you're providing them the report, and you need to give them a reasonable time. Now, it's not stated in the law what a reasonable time is, but 5 days is typically common for employers to allow them 5 days. I might give them 10 just to look good if we had to go to trial later. And then if you make the decision, if they don't provide anything, they don't contest it, or if they do and you still are going not to hire them, you need to provide a second letter called the adverse action letter. Now this letter must include the name, address, and phone number of the reporting agency, a statement that the agency itself had no role in the decision not to hire, a statement that the applicant has a right to dispute the information in the report, a statement that the applicant can request additional copies of the report. I believe it's up to 60 days, and as many as they want. If for some reason they want 20 of them, you've got to give them. And then finally, you give them yet another copy of the summary of your rights circular. So with that, I'll take questions. I covered that rather quickly.
If you were a small employer then, if you were an advisor to a small employer, would you recommend that they go through any of these processes without legal assistance?
Well, I think that it always,
Being an applicant, for example.
well, I think it always makes sense to make sure that your processes are kosher generally. Now, if you have somebody that's unusual. So, for example, if you have a company that installs heating and air conditioning, and you don't have a specific need to know criminal background. I mean, sometimes employers have a feeling that they don't want to hire people with certain criminal backgrounds. Others, of course, I was going through the brochures. There are tax benefits to actually hiring people with a criminal background. So, I think the first thing is, do we feel that that information is important to our organization and the people we hire? I guess the very first question is, are we mandated by any law? Which is something that an employment lawyer can tell you.
So if
Why
I'm
not?
heating and air conditioning,
Mhm.
and I'm sending my guy, or gal, into your home to work on your system,
Correct.
I may feel that I need to be careful who I send into your home. Okay? So I get the person who applies and has a offer him a criminal record having to do with violent acts. Do you think that most small employers have the wherewithal to write these kinds of letters?
Oh, I would involve a lawyer to do that. Oh, yeah, no, I would,
If
that's,
I come to this point and say, I'm not going to hire you.
yeah. No, I think it makes sense to have,
I send people into their homes, and I think it's a business necessity.
right.
Would you recommend that they get help doing that? I would.
So yeah, they reminded me to restate the question before I answered it because it's being recorded. So I'm going to attempt to restate your question, which is, in the event that a small employer decides that they are not going to hire an applicant based on their criminal record, and our example was, let's say, a heating and air conditioning company that knows their employees are going to be going into the customers' homes, and during the course of this process determines that an individual applicant has a criminal history that's not too remote, less than 7 years old, of assault and battery, attempted assault, something along those lines, and decides not to hire. Your question is, should the employer try to write them themselves? Do they have the wherewithal? And I think ideally I would just have your employment counsel do it, and they could do a ghost write the letter. But I would, it's probably best, just as I wouldn't attempt to install, I'm not very handy, so I wouldn't attempt to install a heating or air conditioning unit. This is the kind of thing that I can make sure I check all the boxes, that, not to use the box analogy, but that I make sure that everything that should be in the letter is in the letter. I would think that makes a lot of sense. And I think that, so getting back to what I took your question to be originally, which was, should employers be concerned about this type of thing? What I was, and I think I may have misunderstood your question, but I think that would be a good question, and I think that the first question that any employer has to ask is, are we mandated by any law to perform a criminal background search to eliminate candidates that have particular backgrounds? Yeah, exactly. And that's something obviously your employment counsel can figure out. I wouldn't know off the top of my head. I'd have to look it up. But I do think that's something that's important. And then if it's not, then it's kind of an individual question. For example, I can imagine some of my clients, small businesses, that don't fall within any type of law that governs them and requires them to conduct a background search, that might still want to do it because of their personal feeling that they don't want. I don't know. Some people have personal biases that way, and I think that's part of what these laws are intended to do, is to remove those biases But at the same time, I know that many employers don't like to be told who they can and can't hire. And I respect that, because I think that if you build a business, you should have some autonomy. And, without making it too political, I feel like anytime you infringe too much on the employer's autonomy, it can make for bad feelings. And sometimes employers will do what they want regardless of what the law says, and so that can be a problem too.
You recommended your clients use employment application?
I've never thought about it. That would be a question I would probably... So I'll tell you why they could be useful to me as a lawyer. So if someone... So I deal in the world of evidence, and anytime a question comes to me, somebody is proposing to do something, I have to try and see it in hindsight with foresight. So I have to say, if I have to go to trial in 2 years and explain this activity or this conduct to a jury, how's it going to look? And how am I going to make it look? So in the case of an employment application, if you hire someone, they turn out to be, it's funny, and I think a lot of times, I think many in the room will probably relate to this, you'll hire someone and they'll just turn out to be a bad egg. There's just some bad eggs out there, and those tend to be the ones that hang around the longest and are the hardest to get rid of and are the first to file a lawsuit or a claim when something goes wrong or something they can make or characterize as went wrong. And so when those people file a lawsuit for whatever it is, if they've been dishonest on their employment application, that is something that I can show a jury, and I can say, do you see how here he put that he obtained a master's degree from UCLA when he didn't graduate from high school, according to the records that we subpoenaed from his Taft High School. And right there, then I will hammer on that and anything like that to establish that the person cannot be trusted. So everything they say becomes less truthful appearing. So that's one reason why I personally would like to have an application. But I don't know. It's throughout my life before I mean, at some point I started submitting resumes as opposed to completing applications. But all the jobs I had before that, I always had to do an application. So it never occurred to me that you wouldn't do one. And so I'd be interested to know from the HR side of the world why, because I do know that some don't. And I'd be interested in knowing. What are your thoughts on why they...
Signature.
Oh, more work?
No, somebody will sign something.
Oh.
You send me a resume, and I don't get your signature to verify, say
Right.
this is the truth.
Yeah.
About you, so I think that people should use them. Do you think we should go ahead and just tick the box off of our application and forget about it?
Well...
And go post-offer?
Yeah, I mean, the reason I would is, unless there's a reason that the employer really likes to have it on there, is because this is the trend. This has been identified as the best practice by the EEOC. It's possible that the EEOC, if the federal statute changes and requires it, then Californians are going to have to comply, regardless of what California does. So, because as everybody probably knows, the employers in this state or in any state are required to comply with state rules. So the easiest example is overtime. Under federal law, you go 40 hours before an employee earns any overtime. California, it's after 8 hours in any given day. So, and that holds true in all employment laws. So if the federal law changes, which it certainly could. I mean, everybody wonders, well, what's going to happen under Trump? And it doesn't seem like a whole lot's happening under Congress right now anyway, so that may be. But of course, regulations can change. I don't know. But I will say that I think that it'd be a good idea to go ahead and comply with the new legislation. So going back to my example where the person has lied on their resume, well, I had a case in which the person didn't lie on their application, but they omitted my client when they applied for a new job, and in their resume, they just put they were self-employed for this period of time when they worked for my client. So I obtained that from their new employer by a subpoena, and then in the deposition, I was able to say, were you truthful on your resume? You told them the truth? And of course he did. He wouldn't say under oath that he didn't. And then I said, well, why did you tell him that, you didn't include my client? And the only reason I did that was to give him an opportunity to explain it then. I didn't want to hear his explanation for the first time in trial. But, of course, he said, oh, well, he had gotten hurt. It was one of these workers' compensation cases where he comes back and he claims disability discrimination. So he said, I was only there a little while before I got hurt, and so that's why I didn't include it. So he had an explanation, and I was glad I knew it. I still would have rammed it down his throat at trial. We didn't go to trial because nothing goes to trial, but I was available to do that. So as long as somebody ascribes to a document that has their name on top, I think it's kind of like you say, it's their resume, Now I think in some types of work, for example, I'm thinking of an airline case I had in which the employer needed the people to be able to work on weekends, always be available on weekends. And we had it was a person that took a job as a baggage claim handler or baggage handler and worked weekends for about a year, and then decided they wanted to have weekends or Sunday mornings off to attend church, which isn't an unreasonable request, except that this airline operates under a seniority system, and in order to accommodate their request, the individual would have had to step in front of all their coworkers who are more senior to get their Sunday mornings off. And so she brought a religious discrimination claim, and the fact that she had written on the application that she would work nights and weekends, that was specifically asked, was important. I mean, that was a good fact because it says you knew when you took this job that was, and it's not just can you work nights and weekends, yes or no, it's spelled out like a major, the nature of this position will require you to work, and an airline in this position will require you to work nights and weekends. Are you able to do that? And then she checked the box, yes, so we were able to. Of course, that case settles as well, but they're all useful facts. But I think if you had a business in which there were specific things that you needed, timing, or if they had to lift a certain amount, or if a job was very physical, you'd want to know if they had herniated disc, if they took a job. I mean, I guess that's a whole different side of discrimination, but you want to know anyway, right, before they start and hurt themselves, and you have a workers' comp claim your first week. So.
Our application says that if you have any physical disability that would prevent you from lifting, they have to transfer
people.
People, from workers to there and
Yeah.
So we do that.
So, and I think that's reasonable to do that, and this is why I join with you that I think an application in most instances is a good idea, because you can tailor it to what you need, whereas a resume won't talk about, moved residents that were up to 180 pounds or whatever. And then you just have to be careful that if you get an applicant that says, well, I can't lift, this, then you have to engage in the interactive process and make sure you don't, get on the wrong side of a disability discrimination claim. So.
Our application and the process and the offer letter, they're all conditional. Our work is very physical.
Mm-hmm.
They have to go through a physical, fitness test. And
Yeah.
the criteria are all spelled out. We spent a lot of money on having professionals come in and do job requirements, weight lift,
Right.
all that. It's not a perfect system, but it's pretty good.
You've obviously given a lot of thought to it. I mean, that's the thing. So a lot of the employers that I work with, or some of the employers I work with, just don't give that much thought to it. So I end up getting involved later, and that's where we have to try and fix things. So I think that's the biggest takeaway is when we talk about involving counsel or anything is just make sure you're doing it right before something bad happens, you know.
What about after something? What if I call you and I say, Alex,
Well,
my employee's in jail. He was arrested, he was in a big bar fight, and he broke somebody's jaw. What do I do? I can talk like that. My employee's in jail, what do I do?
do you have any obligation to bail them out? I mean, you don't certainly have any obligation to bail them out. Question is whether you keep them after.
Do I keep his job? For how long?
That's a really tough one.
Do I fire him? Do I replace him? Do I?
Yeah.
He'll get arrested, and employers go, okay, now he's arrested, now what do I do? I need somebody on the job.
Yeah, I think unpaid leave. I don't like unpaid leave, but unpaid leave maybe if it's a job where, I don't know. It's a incomplete hypothetical. Yeah, because, if it's not a job where it really matters, if the person's violent in the weekends when they drink. Yeah. Now, if the person's in jail and you have a 3-day no-show, you don't have to keep their position open forever if they're in jail and they can't bail themselves out. And
I don't know how that works specifically.
yeah,
As far as like the unemployment thing.
yeah. I worry less about that, unemployment benefits, typically for my clients, although it matters to them, than I do about them getting a claim or a lawsuit. I mean, that's the...
But I would imagine that like if violence and justice is faced, and they could be kind of worse, and they say, hey, what could happen to you? Like things happen in life.
Well, bear in mind, though, that it is an at-will employment. So if subject to the protected classifications, you don't have to keep somebody employed, right?
I mean, like if someone got in a car accident, you didn't even find out for a week. What would you do?
Well, if it was your car, you mean the company's car or their own car? So I basically have this case right now. It's brand new, and we have a guy who is in another state. He's a sales guy, and he apparently has some kind of illness which sticks him in the hospital. He claims he cannot contact the employer for a week. 3 days come and go. They don't like him. They let him go. They terminate him. He lets them know as soon as he gets out of the hospital. This is his version of events. We haven't taken his deposition or anything. That once he gets out, he says, well, I was in the hospital. I couldn't call you. I want my job back. What are you doing terminating? And he said, well, we have the policy. It's in the handbook, and you're aware of it, and that's what it is. So now he has filed a lawsuit claiming disability discrimination, failure to accommodate, failure to engage in the interactive process. He's also claimed he's a Caucasian male, and he is sued in the Los Angeles Superior Court in downtown LA, which is the same venue that exonerated O.J. Simpson from a criminal case. He is also suing because an African-American female was promoted in place of him for his job. And of course, my client has a whole bunch of reasons why that happened. Now I have to evaluate the truth of that. So it's not just this. He's got all these claims to it, and it's got everything in the book. I think it's kind of an absurd claim to claim reverse discrimination by a Caucasian male for the advancement of an African American female, but I haven't heard of it really. But as to the disability, the question arose: well, does the employer have a duty once they've let the person go to take them back? And the case that I found said that unless the employer knew of the disability, they had no duty to accommodate, no duty to engage in the interactive process, and if they evenly followed. Now, this is one thing the other side's going to try and prove, which is, there were several instances in which people didn't show up for 3 days, but you didn't fire them. And I don't yet know if that stuff's going to come out of the woodwork. And if it does, then that's bad for my client.
It's just kind of funny, just on a personal level, I took my first day back to work since last Tuesday at 3 in the morning. I went to the ER, and 5 hours later, I had emergency surgery.
Oh,
So, this is
Yeah.
my first day back from last Tuesday, and you know what? My employer knew I was gone that day, right? I had surgery. I could still find some way, somebody to contact
Yeah.
the employer and say, yeah, I didn't show up today. Did I call them first thing? Did they wonder where I was probably initially? Yeah, but by the afternoon, they do. So to me, it's,
You can bet that I'm going to be deposing this guy's
Right.
sister, mother, wife. I don't know anything about him yet, but I'm going to find out. So when did you learn? And
well, that's the
so
first thing on my mind
yeah.
too. It wasn't
Yeah.
even like, oh, I'll just maybe call him tomorrow. It's
Yeah.
like, oh, somebody needs to call my work. It's
Yeah.
not gonna be that.
Hospitals
So-
have telephones.
they do, they do,
That's not it.
they do.
Ask
So
the nurse
yeah.
or anyone that works there for a telephone.
Yeah, so it'll be an interesting case, though. I'm kind of excited about it. That's one thing about litigation that I like, is it has all this stuff, and you discover it through doing the discovery process of subpoenas and depositions, and it's that part I really, really enjoy. So, any other questions?
Any other questions for,
Do you mention California at will?
Yeah. Unless you put in an agreement that it's not. So, for example, if you're an athlete, typically you'll sign a 2-year agreement. But no, otherwise it's an at-will state. Now, many of my clients who aren't as sophisticated, probably as all of you in the room, will say, well, I can hire and fire whoever and whenever I please. And I say, well, that's true, but you need to be aware that, unless they don't fall within any category, they can probably get into the courthouse with a claim that you're doing whatever you did, firing them, because of their race, their religion, their disability, their anything. And they'll probably make it really expensive and miserable for you, even if they couldn't ultimately prove that you fired them because of this protected classification. So I caution them, about doing that. So at will is a dangerous word or phrase in a way, but it's true.
because isn't almost everybody in some protected class? I mean, over 40, and,
Yeah.
there's so.
I mean, if you get a 30-year-old white male who's completely healthy, doesn't get depressed, doesn't take Zoloft. I mean, pretty much anything can.
Right.
You're right. It's very, very rare to get. And candidly, as this new case is showing me, because they're also making a gender discrimination claim in addition to the race discrimination. So you could be, now he's over 40, so he's also making an age discrimination claim. But if he had been under 40, he could still say, well, she was promoted ahead of me because of our gender difference. So, yeah, you're right. Everything's a protected class.
You're certainly right about the issue is
Avoiding the lawyers.
Thank you very much.
Absolutely. Thank you for the opportunity.
Thank you all.